Good afternoon, and welcome to CESLC Insider, where you can join us to find education on topics that matter to you. I'm your host, Angelique Jackson, Manager of Business Development and Marketing. And here at Charles E. Smith Life Communities, we deliver care and experiences personally tailored to those we serve, no matter where they are in life's journey. Our full suite of care and services include independent living, assisted living, memory care and support, post-acute and long-term care, as well as primary care with a focus on older adults at Hirsch Health Center. To explore all our campus has to offer, you can visit our website at www.smithlifecommunities.org, or you can call the Welcome Center to schedule your private tour today at 301-228-0641. For your convenience, all that information will be provided to you in the chat. And I just want to thank everyone who tuned in today. We want to hear from you, so please add your questions to the chat. And also a big thank you to Optum, our sponsor for all of our insider events. We truly appreciate your partnership. I just want to give you a few reminders before we begin today. We will be recording today's webinar. This recorded version will be uploaded to our YouTube channel, and there you will find past programs and much more. You can find that link in the chat as well. So joining us today to give us an overview of estate planning fundamentals and provide the tools and resources to empower us to create a roadmap for our legacy is our guest, Jenica E. Cassidy, elder law attorney at Lurch, Early, and Brewer. Jenica works with older adults and their families of all income levels with legal issues related to aging, helping them to plan for and resolve legal issues. She is a frequent speaker and author, presenting and writing on guardianship issues for the National Aging and Law Conference, the American Bar Association Commission on Law and Aging, and the Elder Law Journal. Jenica, thank you so much for joining us today and sharing your time and expertise. So what led you to your passion for elder law?
Thank you, Angelique. Happy to be here. Elder law is one of those funny terms. You know, I've been practicing elder law for many years, and I know a lot of other elder law practitioners, but I don't love the term because it means different things to different people, and sometimes people have never heard of it. It's generally, I help clients with issues that that arise due to aging. So I am in the estates and trust practice group at my firm in Bethesda, meaning we do a lot of estate planning for a wide range of clients, from 18 all the way up to 100. And we also do estate administration, meaning when folks have passed away and they've named someone, or maybe they haven't named someone to administer their estate, we help those people to do so. Elder law also encompasses other issues such as guardianship, which we can get into, incapacity, what happens if a loved one or you yourself loses the ability to make and communicate decisions and handle your financial affairs and you need help to do so. What happens? How do we do that? How do we pay for the rising cost of long-term care? What are our options? That's generally elder law, but I like to break it down into components that are familiar for most of us to understand.
Thank you so much for that overview. And to really get started on today's topic, I'm going to ask you, what is an estate plan? Why do we need one? And when should we begin the process of estate planning, or even just planning for, things that are related to aging and our later in life care needs?
So an estate plan is legal formal documents that we have in place to handle that we have directed, where we've named someone to handle our affairs if there ever comes a time when we aren't able to handle our affairs on our own, we become incapacitated, or we just need help doing so. And also when we pass away. So I break it out into those two separate components, although they are all part of one estate plan, and a full estate plan should have both. Some people may just have a will. That will only comes into play when they've passed away. Some people may only have a power of attorney. That power of attorney becomes legally ineffective upon their death. And then within those documents, in addition to naming someone who's going to handle our affairs, meaning our finances and our healthcare personal affairs, we also direct what we want to happen within that plan. So from a broad approach, that's how that looks. What was the second part of that question? I want to make sure that I answer
it. Why do we need one? Which I think that you kind of, you've answered that.
You know, we all need one. I have clients as young as 18 who I sit down with them and we do really basic documents. We all need one when we turn 18, because the reality is, last I checked, none of us are going to beat death, right? These are not fun things to think about, but this is our reality. And what I tell my clients is, by dedicating some time to thinking about these things and putting a plan in place that's actually legally effective, we are giving a gift to our loved ones, a gift to our family, a gift to our friends, because we're taking the burden off of them and handling it ourselves initially. So ideally, we sit down, we create the documents, and then we don't have to think about them again until, our wishes change, which they certainly can, or, sorry, I saw a notice there, or our life changes. So there's a major life event, someone passes away, we get a divorce, we get remarried, we have another child. Otherwise, these documents we can put them away and we can know that they're done and taken care of, and we are not leaving so much of a crisis to our family members and our loved ones if we end up in one of these situations.
So you mentioned that we should begin as early as 18. And in doing a little bit of research and preparing for this webinar, I saw that 67% of Americans don't have these documents in place. Why do you think that this gets overlooked?
In my humble opinion, I think it's because these are tough topics and it's easy to put them off. I think many of us have this on our to-do list, our never-ending to-do list of things that we want to get taken care of. And it can get pushed to the bottom. And because the cost involved, attorneys are expensive. And so I think the combination of those two is the reality that's in place as to why many folks don't have a plan in place. But like I said, if we take a little bit of time and we think about our options now and we actually get documents in place now, then it's going to avoid major headaches down the road, which I have countless scenarios that I'm happy to talk about, of a variety of clients who come to me. Someone hasn't had an accident, they've had a stroke, maybe they've had a diagnosis of dementia, maybe they've passed away, and their loved ones are left to clean up the mess, so to speak, and they're not even sure where to begin. So we want to avoid that scenario.
Yeah, so making sure that your loved ones, it's essentially, if you can't make your own decisions or if you have passed, you still have a voice. Exactly. Or it provides your loved one with the direction of how you would like your assets and things or your care to be handled.
Exactly. Yes.
So how should we begin the process of planning our estate or preparing these documents, what's a good starting point for even like managing and organizing our finances, either for ourselves or if we're helping someone that we love or a friend.
So I think it's helpful to think of it in terms of two components: finances and personal affairs. By personal affairs, I mean healthcare, I mean decisions like where we're going to live, things like that.
Mhm.
So for finances, step one for ourselves, or if we are trying to sit down with someone else who we think in the future we're going to need to be involved in their affairs and we aren't sure, or we know that they haven't done any pre-planning, write down the list of assets. Get it written down on a piece of paper. Determine, and this is all financial assets: bank accounts, real estate, life insurance policies, retirement accounts. I'm not really so much talking about personal items in the home unless there's something like a valuable coin collection or something like that. But determine what the assets are, determine the owners. So for a bank account, is there one person on the account? Is there a joint owner? Is there someone on the account who is not an owner, but they are named as a power of attorney, perhaps, with authority to access the funds in that account, but the funds aren't necessarily theirs? Is that how we want the account to be structured? Such that if we've named, say I have an account and I've named my daughter on the account because if something happens to me, I want her to be able to step in and handle and pay my bills. Well, if my daughter gets a creditor judgment issued against her, those creditors can access the funds in that account. If I pass away, those funds automatically become my daughter's funds without going through the probate process. If I want to leave them to equally amongst my children, too bad. They all go to my daughter. I say those examples as a way for us to think about, is this how we want the ownership structure of the assets to be set up? Third, determine who has legal authority to access those assets, if anyone. Do we have a power of attorney in place? If so, if we have a power of attorney, does the bank have a copy of it? Are they aware of it? They don't necessarily need to be aware of it, but I recommend that if you have a power of attorney, you provide it to your bank in advance, because it can take the banks days to weeks for them to process those documents and to get the power of attorney person appointed with the proper legal authority to do what they need to do regarding the account. Fourth, determine who the beneficiary designations are, if any. Meaning, for a life insurance policy, where are the funds going to go when we pass away? Have we designated our spouse as the primary beneficiary on a retirement account? Have we designated a trust? Who do we want to receive? We can even do this for most simple checking accounts. That's where I would start. And then from there, you can build out what additional documents you may need to put in place in terms of a power of attorney, in terms of a will or a trust, which we can get into, for the finances. For the healthcare side of it, I would start by determining if we have done an advanced healthcare directive. And I think this is getting into the later questions, so we can probably pause on that. But that's a good, basic, simple rundown for the financial component.
Thank you. And you're right. So you did mention certain documents like the POA and wills. What other kinds of legal documents should we consider putting in place, either for ourselves or our loved ones? And can these documents be changed or amended?
Sure. And just so everyone's clear, the power of attorney it's a financial document where we're designating someone who has legal authority to access, manage our finances should there come a time when we're unable to do so on our own. So we can make the power of attorney effective upon signing it, or we can make it effective upon a doctor determining that we lack capacity to handle our own affairs. So if something happens to us, the person who we've designated, they bring the document to the bank. They say, I've got to pay this person's bills. Here is the doctor's note indicating that they lack capacity. Here's the power of attorney. And then they have legal authority to write checks, access income, sell real estate. The power of attorney can be limited, or it can be as broad as essentially you're allowing the person to step into your shoes. In Maryland, and a lot of what I'm talking about is Maryland specific. I practice Maryland, DC, and a little bit of Virginia, but primarily Maryland. So, and some of this stuff is pretty state specific, but a lot of it is just general knowledge. So in Maryland, what I want to point out, for every Maryland resident, there's something called a Maryland statutory form power of attorney. And it's available if you Google Maryland Attorney General statutory power of attorney. Every Maryland resident should have one. It is a form that by law, the banks are required to accept, so long as it's signed and notarized. It needs witnesses and notaries and things like that. But they were running into issues. I think maybe about 10 years ago, the legislature passed a law. They're running into issues where someone would do a power of attorney. They go through all of the work and effort, and then the person that they've designated, who we call their agent, brings the document to the bank, and the bank says, well, this is not our specific power of attorney, our PNC power of attorney, so we're not going to honor it, which defeats the whole purpose of even having a power of attorney in the first place.
Mm-hmm.
So Maryland passed a law stating if you have what's called the statutory form, then by law, banks are required to accept it. In addition to that, I also have my clients do another power of attorney, and they kind of work in conjunction together. I just think that my power of attorney is a little bit better than the statutory form, but I think it's because of that protection in place where banks are required to accept it, I have my clients complete both. So everyone today, at the very least, should go online. It's free to do that. You just got to make sure you witness and notarize it correctly. In addition to that, there is the Advanced Healthcare Directive. That is very similar to the power of attorney, where we're naming someone to help us with our affairs if something happens to us. It's unique in that it's just for healthcare. And some people may be familiar with terms like living will or healthcare power of attorney. We like to keep things confusing.
I know, there's so many. Yeah.
But in Maryland, this is called an Advanced Healthcare Directive. So in addition to naming a trusted person who can speak to our doctors, access our medical records, make medical decisions for us, determine, yes, provide informed consent for medication changes, surgeries, everything like that, if we aren't able to do so on our own. We can also use this document to designate specific wishes that we want for our healthcare providers to adhere to if we are in certain scenarios. So, for example, if you are in an end stage condition where your doctors have certified that even with all medical interventions taken, it's unlikely that any interventions are going to extend your life. Mm-hmm. What do you want to happen in that scenario? You're not able to communicate that to your doctor. Do you want pain medication? Do you want a feeding tube? Do you want nothing? Do you want to be sent home in peace? Do you want all measures taken to try to extend your life? These are really, really difficult situations. And if we don't, like I said before, if we take a little bit of time now to think about what we would want in that scenario and put that in writing and make it legally effective, then it's a gift that we're giving to our loved ones where they don't have to agonize over the decision, right? So I also like to include in the Advanced Healthcare Directive, if clients want to, things like what happens upon their death in terms of funeral and burial situations. If someone feels strongly about being cremated, or I even have some clients that know exactly what music they want played at their ceremony, what flowers they'd like to have there. I put all of that in this document because if we put it in the will usually doesn't even get looked at until well after all of that stuff has occurred. But the POA, the power of attorney, and the advance directive are legally effective while we're still alive if we lose capacity. They work together to avoid a guardianship. Guardianship is, some of us may be familiar with guardianship. It's a court procedure where a judge, or it could be a jury, but it's oftentimes a judge, will appoint someone else to handle our affairs, whether that's medical or financial, because we are deemed to lack capacity to do so, and there's no one else with legal authority who is able to handle our affairs, meaning we don't have these documents in place already, or we have them in place and there's an issue with them, or there's no one who we've named that is willing and able and available to serve, whatever it may be. Something needs to be done to handle our, whether that's a medical decision or whether that's accessing our money, whatever it may be, and we're not able to do it. So someone's got to then oftentimes hire an attorney, go to court. A judge is deciding, and it's a pretty big deal because a judge is stripping you of your basic civil liberties to make decisions like, how do I spend my money? Where do I live? Who are my visitors? And giving those decisions to someone else. And so we want to avoid that. It's necessary and appropriate as a worst case scenario, right? If we have exhausted all of other efforts and there's nothing else available, guardianship is there if we need it, but we want to avoid it if we can. So we do that with the POA and the advance directive. And then upon our death, that's when the will takes effect. And that's when the things like the beneficiary designations and the revocable trust, if we have that in place, also takes effect. Should we get into those now or later?
Yeah, I think we should. And I just wanted to say, I wonder if folks knew that if they didn't have the proper planning, that they would lose their civil liberties and their ability to make decisions.
Yeah, it is
certainly
drastic. And there's, I've seen scenarios where an attorney is appointed because there's no one else able to serve in that role. And this attorney has never met this individual.
Right.
And they may never meet this individual, but they have total control over their life, which is a pretty big deal. So let's try to avoid it if we can.
By proper planning. And then you were just getting into trusts, which I think is an important topic to touch on.
So when we pass away, we were all familiar, I'm presuming, with what a will does. A will administers our probate estate. And probate is the key word there. What is probate? Probate is assets that, let's think of them as assets that don't have a joint owner, whereby the joint owner automatically takes ownership of that asset when we pass away. And they don't have a beneficiary designation. So these are things like a bank account that doesn't have a beneficiary and doesn't have a joint owner. These are things like real estate, where if you're the sole owner of a home. These are things like the things within our house, our furniture, our cars, our personal items. If we have not designated a beneficiary of our life insurance policy, it goes into our probate estate. And no one has any legal authority to do anything with our finances until they are appointed as a personal representative by a court, meaning when someone dies, some of us on this Zoom have probably had to do this. We take the death certificate and the will, if they have one, to the courthouse, and we file a petition to open a probate estate. And the court is then going to appoint you. Hopefully there's no one fighting over the will, or no one else saying, actually, I'm the person who should be administering this estate. That can delay the whole process, but probate is the legal process by where we administer the estate. Once an estate is open, if we die with any creditors, if we die with a visa bill, visa has to file a claim against the estate, and visa has priority to get paid from the estate assets before anyone else. So creditors have to adhere to a strict process. The person administering the estate has to file documents by a certain date. These are all public records. We can all go, any one of us can go online right now and look up the estate of any estate that's being administered in Maryland and download documents. We can download accountings, a whole host of items. And so it's all public records. So that's how a will is administered. If we die without a will, it's a similar process, but the distribution of our assets and who is administering our estate is all dependent upon what we call the intestate laws. So these are statutes that indicate who gets what based upon our family. If we die with a spouse, if we die with living children, what may be. The will is where we can control and override many of those intestate laws. A trust and a revocable trust is a common document that folks use to replace the will. So we use a revocable trust in conjunction with what's called a pour over will. That says, it's a very simple will that says, if I die and I have probate assets, I don't want them to go through probate. I want them to pour over into my revocable trust. It's revocable, meaning we can change it while we're still alive. We can get rid of it. We can do whatever we like. When we pass away, it becomes automatically irrevocable. No one else can change it. And then our estate distributes according to the terms of the trust. We avoid probate that way. We avoid the creditor process. We avoid a lot of filing requirements, a lot of notice requirements. We avoid having our estate be subject to public, anyone being, it's much more private in that sense. A lot of in terms of things like tax planning and details that I'm happy to answer, questions people may have regarding leaving assets to minors or to folks who perhaps they have a substance abuse history and we're concerned that writing them a big check may cause some issues. We want to put protective measures in place for things like if a loved one has disabilities and we are worried about them losing their public benefits, if they receive a large inheritance, what can we do there? We can set all of that up within the trust. We can also do a lot of that within the will, but the biggest component of the trust is that it avoids the probate process.
Very important.
Yes.
Thank you. Thank you so much. You know, I think if folks knew this, they would be willing to take the extra steps to complete this process. And so I just want to get to a few questions that we have already.
Sure.
So our first question, and you mentioned something about taxes, is special needs trust income really tax-free?
Special needs trust so we're talking about an asset that is held within a special needs trust or an individual who has disabilities, and that asset, say it's an investment account, is earning interest or dividends. That's the question?
Maybe Richard is the one who asked the question. Maybe if you could be more specific in the chat as to this question, and we can get back to it.
That's exactly what I meant.
Oh, thank you for the clarification.
So there are certain trusts are taxed depending upon a whole host of factors. One of the major ones is whether it's a grantor trust. So, for example, with a revocable trust, it's a grantor trust, meaning that there's no separate tax component. It uses the same. If the revocable trust is earning income, we report it on our income tax documents for us as individuals, and there doesn't need any separate EIN. For a special needs trust, oftentimes there is a separate EIN, and I'm not sure if I know the answer to that. I do a decent amount of special needs trusts, but I often draft them right into the revocable trust. And so if you are looking to set up a separate special needs trust for a loved one, email me or send me a note directly, and I'm happy to connect you with an attorney that I refer a lot of folks to who just does special needs plannings for folks with loved ones with disabilities that they'd like to leave an inheritance to, and she can answer that question.
Thank you, and thank you for your question. So the next question has a little bit of a two-part. If someone has received a settlement check, can someone who has been assigned as an executor deposit the check, or does it need to go into a trust estate account? And that the person that the settlement check has been addressed to is now deceased.
So they receive the settlement check and it's made out, I'm presuming, to the person who's passed away. There's been an executor who is also, it's another term for personal representative, appointed for the estate. They would then have authority to take that check. They should deposit it into the estate account. Yes.
Thank you. Great question. My next question, the next question is, they're saying, I have a will, trust, and other documents. There are some small changes needed. What would be the typical cost of making these small changes?
So the way to change a will, it's called a codicil, and it's a legal document that's signed in the same formalities as signing a will. And then it's attached to the original will. And we can also file the codicil with if the original will is filed with the court in the county where the person resides. That's for simple changes. If you have more substantial changes, I would recommend going back to the attorney that's drafted the will, so long as you're happy with what they provided, because they're going to have the Word document in place. So oftentimes it's easier for us to just pull up the Word document of the will, make the changes that you would like, and then re-sign the will. And then that will takes precedent based upon when you've signed it. And we destroy the prior will.
Great question. Thank you. Hope that was helpful. And then our next question is how to find a reasonably priced, reliable lawyer in Montgomery County.
Good question. I think it's perfectly appropriate to ask people their rates up front and whether they do a flat fee or whether they charge you by the hour. And many of us I do a free initial consultation with folks because I think that it's, we have to gauge each other out and sense if we have a good working compatibility, and can provide to you, I offer you, based upon your scenario and your wishes, my suggestions about what you should do and how much time I think that would take me. My hourly rate is $2.90, and I can generally give folks a range of what I think the total cost would be based upon what they want to do. If they just have a couple changes to make to a will and we're just going to do a pretty simple codicil, it's going to take me a couple hours. Maybe I can even have my paralegal prepare it, and then I review it, and then you come in and we sign it and I send you on your way. If it's going to be something more extensive, if we're setting up the full estate plan along with revocable trusts for perhaps a husband and wife, and within those trusts we are establishing additional trusts, then it's going to be more extensive, and I provide my clients with a range of what I think the total cost would be It's usually, for me personally, it's usually for the full estate plan, it's usually somewhere around like $5,000. Although that can certainly be more, can certainly be less.
Yeah, because our viewer said that they were charged $2,000 just to change the name of the executor.
Oh boy,
Yeah.
that's
Okay.
a lot. And I'm sorry that, and I hope that what didn't come as a surprise.
Yeah.
I think that as attorneys, it's up to us to clearly communicate to our clients in advance if we think that something's going to take us additional time. You know, sometimes surprises come up, and that's just the reality. And things can cost more. And in my experience, it just helps to be really upfront about that initially. So 2,000 for that, for just making a simple change, seems high to me.
Yeah. And thank you. It was a great question. Our next viewer is asking, again, just the website for the Maryland Statutory POA form. And I can put it in the chat.
If you Google, let's see, I'm going to pull up Google. If you Google Maryland Attorney General Statutory Power of Attorney, there should be, let's see, marylandattorneygeneral.gov is the website. And then, yeah, I'm looking at the form right here. So that's the best way to access that form.
I'll put it right here. So marylandattorneygeneral.gov.
Yes.
And I put it in the chat. So thank you so much for that. So another one of our viewers is asking about the MOLST form in Maryland.
That's a great question.
Yeah, it is a great question.
That is a form that is meant to work in conjunction with your advanced healthcare directive, and also with a DNR, a do not resuscitate, if that's something that you wish to complete. Those forms, the MOLST form and the DNR, are they're doctor's orders. I know the MOLST form is. The DNR, I'm pretty sure, but you have to sit down with your doctor to complete those. You don't do that with your attorney. So what I recommend is that and the DNR is end of life care. The MOLST form is broader. Once you have your advanced healthcare directive, then you bring it with to your doctor. You should already be giving your doctor a copy of it anyways, and sit down with your doctor to complete the additional MOLST form, and then store all of those together in one location. So they're all meant to work together.
Thank you. Our next question, and forgive me if I'm messing it up, it says, is making, I guess, my wife equal legally, what's the term needed, equal enough on accounts and important property?
Is making my wife
equal legally equal enough to on accounts and important property? So I guess trying to make sure that his wife is joint ownership on accounts and property. And forgive me if Harry, if I mangled the question, if you want to follow up with an additional question in the chat.
Yeah, Harry, please speak up to clarify the question. But if you want to give your wife legal authority to act, the best way to do it, and there's no guarantee even that she's your wife, that if you haven't done any planning, that she's going to have any legal authority to do anything regarding your affairs and your assets. So the best way to do that is to designate her as your power of attorney. If you want her to have, so the power of attorney is different than her owning the asset. With the power of attorney, you're naming her as your fiduciary, meaning she has a fiduciary obligation to manage and handle your financial affairs on your behalf. She can't run off to Mexico with all of your money. The law says she's got to honor your wishes regarding your finances and spend them on your behalf. That's separate from her being an owner with equal authority to access a bank account, even if all of the funds in that account are yours. Am I answering your question? Yes or no?
I'll find it down here, but thank you. I'll find you the clarification if you've typed it in, Harry. So our next question is, can one without family or others to take over find their own guardian before needed? And they're kind of thinking like of an interview process from a pool of guardians that, you know, they think that would be in alignment with their needs and wishes.
Good question. The court in Maryland does not allow us, will not do anything regarding a guardianship prior to when the guardian is needed for an adult. Parents can designate guardians for minor children if something were to happen to the parents. But for adult guardianship, the court is not going to do anything, honor anything regarding the guardianship until and unless the person is incapacitated and they need a guardian appointed to handle their affairs. Now, we can designate in our power of attorney and our advanced healthcare directive documents who we would want the court to appoint as our guardian if it ever comes to be that we need one. And for some reason, the power of attorney is not sufficient, and so we need a guardian in place. Then we can say, court, I want you to appoint so-and-so. And if we are thinking about it and we're not sure that we have anyone in mind that we would trust enough to name to help us with our financial or personal affairs, then I would certainly talk to your attorney about that. I have clients who are in similar situations, and I can offer a whole host of suggestions. Sometimes even attorneys will name sometimes even clients will name their attorney to handle their affairs. And that it's not a conflict of, it requires a little bit more planning from the attorney side, but it's not a conflict of interest. You know, it's very specific to the relationship between the attorney and the client. But it's something that can be done. There are professionals who can serve as fiduciaries. Of course, they charge a fee. I'm not sure if there's anyone who would serve in a healthcare decision-making role other than the county, when the county will do it if there's no one else. So sometimes folks end up, say, in a nursing home and there's no family involved and the doctor needs to perform a procedure and they can't get informed consent, then the county will step in, the Montgomery County Department of Health and Human Services, and make that decision, only if they have to. But we can't designate the county.
Great question. That was a really great question. Complicated.
It is. Talk with your attorney. It's a good question, and it's a scenario that is not uncommon. So,
and thank you for that question. So our next question is there anything similar to a quick claim deed in the state of Maryland?
I wish there should be. No, I think a few years ago they tried to pass. This is something where we can avoid the probate process for real estate. Okay. That doesn't have joint owners. But no. What we do is we put the real estate into the revocable trust. So we quit claim it into the trust while we're still alive. We own that it doesn't change anything regarding the tax components or the ownership components of the property itself. The trust is the legal owner, but it doesn't change anything in terms of how we can still maintain a mortgage on the property. We can still have it properly insured, everything like this. We can still sell it if we want to sell it, because the revocable trust, like I said, is a grantor trust. It's treated very similarly to us as an individual. But when we pass away, the real estate within that trust avoids probate And the trustee who we've named to handle our trust when we die automatically has legal authority to step in and direct where that property goes, meaning they then deed it out to the new owner per the terms of the trust, or they sell it per the terms of the trust. They do whatever they need to do, avoiding the probate process. That's what we do in Maryland.
Great question, and I hope that was helpful. Is there a if there is a pour over will and a revocable trust and $100,000 account, then are you saying that $100,000 does not go to probate? That's our next question, which is a really good question.
It is a good question. So this is a checking account that we have not designated the trust. So after we set up the revocable trust with the pour over will, then we need to update our beneficiary designations, which is a separate form with each bank. Each financial institution has their own beneficiary designation forms to update, to name the trust. We either name the trust as the primary beneficiary, or we can name, for example, we can name our spouse as the primary beneficiary and our trust as our secondary beneficiary, which is another common approach. So if we have not done that, then those assets, unfortunately, have to go through the probate process. So we've got to then, that's why we have the pour over will, just in case something like that comes up. Then yes, you've got to go probate the will. And then, okay, what does the will say? It says, any of my probate assets pour over into my trust. Okay, well, these assets are going to then pour into the trust account, the bank account that's in the name of the trust. But first, it's got to go through the probate process. Creditors can file claims against the estate, A, B, C, and D. But yeah, it's yes is the short answer.
So without a beneficiary being designated, if there is no beneficiary that's designated and the person dies with a $100,000 account, even though he has a pour over will, even though he has a revocable trust, if nobody has been named as a beneficiary, you are saying that it still, at that point, does go through probate.
Correct.
Correct. I think that is correct. Because I thought earlier you said that having a pour over will and a revocable trust avoided probate. But
sorry for the confusion. It's
right.
the pour over will is meant to catch any assets that didn't end up in the trust. Either while we're still alive, we're putting the assets in the trust, or we're naming the trust as beneficiary to dump into the trust when we die.
But it does not avoid probate.
Correct.
Right.
But in order to get those funds into the trust or do anything with those funds, you've got to probate the will, because those assets are going to be in the individual who's died in their individual name, and it's going to be considered a probate asset.
Right. I think there are a lot of people under the misconception that with a pour over will and a revocable trust that they will not have to go through probate, but that's not accurate. They might still have to go through probate.
Yes, your attorney should be giving you, when you either talking about this in the early stages, or what I do with my clients is after we've signed the forms and I send them on their merry way, I send them with a cover letter stating these are the additional steps you need to take on your own. You can certainly use my help, but you can do a lot of this on your own. Contact your bank, update your beneficiary designations.
Thank you. And thank you for the, the clarification.
Sure.
And there was kind of a follow-up. Does a will or revocable trust have to be prepared by an attorney?
No, I mean, no is the short answer, but ooh, that makes me nervous.
Right.
That's my answer. No, but it makes me nervous.
Okay. Moving on. What is the best place for the original documents to be kept? Should it be in a bank, a safe deposit, in a vault with the attorney?
Not say a safe deposit box. Those are so hard to access. And sometimes our loved ones don't even know if they exist. We have to get a court order to access those sometimes, which is a headache. I would say, so for my clients, and I presume many other attorneys, they offer storage. So we offer at no extra cost. We'll store the originals for our clients. We'll send them copies, to store virtually, and then also hard copies. And then we will keep the originals in a secured warehouse, fireproof, weatherproof warehouse. And if the originals are ever needed by someone who has legal authority to access them, then it takes about a day or two for us to get those over to the individual. There is an option to record your will if you're not going to do a trust and you know that your family's going to have to go through the probate process when you die. You can record your will in the county register of wills for the county where you live. So I think it's like a $5 or $10 fee. And if you just call them up, especially Montgomery County Register of Wills, I think they're phenomenal. We're really lucky in Montgomery County to have them. You can store the original there, let your loved ones know, or the person who you have asked to administer your estate, this is where the original is. Mm-hmm. And that's a simple process to keep it. If you want to keep it yourself, that's fine. Keep it, stored in a secured fireproof box or bag or somewhere in your house. Just let people know where they are, or else they've lost their purpose. If you complete these documents and you lock them away somewhere and you don't tell anyone that they exist, it's defeated.
Defeats the purpose, right?
Are photocopies of them actionable? Photocopy of the will, photocopy of the trust?
It can be. If the will is lost or destroyed, there's a way to probate a copy, but you've got to sign an affidavit indicating these are my efforts that I've gone through to locate the will. Can be. And certainly sometimes that's the only option, is to probate a copy. For power of attorney documents, a bank is generally going to want to see an original. But oftentimes in my experience, the bank wants to at least see the original. Don't let them keep the original, have them update their records, and then make a copy and then give the original back to you.
And trusts, copy of a trust?
Many copies of trusts within so long as the trust document authorizes the use of copies, and that's fine. Again, in practice, oftentimes the bank is going to want to see an original.
Thank you. And then also, please remember to add your questions to the chat, and we will get to them. So our next question, can you add your children to your deed so that they can inherit the home when you pass away?
So there's something called a life estate. It's different from something called what we call owning property in fee simple, meaning we own the entire interest of the property, and when we die, we can direct where we want that property to go based upon other documents, not within the deed. The life estate is where we own the deed, or we own the property for the duration of, could be for the duration of our life, the duration of someone else's life. When we die, when they die, what's called the remainderman automatically takes legal ownership of that property. Don't do that before talking to an attorney, because there's other implications that can come up. But in Maryland, we don't have the option otherwise within the deed to designate who gets our property when we die. That's why we oftentimes will put the property into the trust, the revocable trust. And then within the trust, we direct what we want to happen to that property.
Thank you, because the next question was, what is life estate deed? And so that kind of ties hand in hand with that question. And then I just want to let you know, and everybody know, that we're 2 minutes to time at 1 o'clock. It's been going so fast. We've had such great questions. Are you okay we might go over a few minutes. It's Is that okay? Or should we keep going? We have, I think, a few more questions. If not, we can let everyone know how to get in contact with you if they
Sure.
have
Yeah, I'm
further.
happy to share my email. I answer my phone and I look at my email directly. So if folks want to contact me directly, I'm happy to follow up on questions. Do you mind putting my email and my phone number in the chat for folks?
Yes, I will.
Okay, thank you. Or you can just Google me. I may be the only attorney Jenica Cassidy in our area. So you can also Google me and find me that way. My email's on our website. Let's see, was there?
There's a few more questions here.
Okay. And I do need to wrap up at 1 o'clock though.
So what happens to the trust if you have to go into a nursing home? Which I think this is a great question.
Yeah, and we haven't really even gotten into long-term care, which is a whole nother topic.
Yes.
What happens to the trust if you go into a nursing home?
Yes.
Well, as attorneys like to say, it depends. We're talking about a revocable trust, I'm assuming. And if we're in the nursing home, then, and we don't have capacity, then we have assets that are within our revocable trust. So there's the trust, but then the trust has to be funded with assets. Then we've named a successor trustee to handle the assets within that trust if they need to be handled while we're in the nursing home. If we need to qualify for some sort of public benefit, maybe we are eligible for a benefit through the VA, or we need Medicaid because long-term care is extremely expensive. And if the facility where we're at accepts Medicaid, then the assets within the revocable trust are not going to be protected in terms of helping you qualify for means tested public benefits. Yeah, I'm not sure again if I'm answering that question properly, but I guess it depends.
Well, thank you. And I know we've had so many questions. I do apologize if we weren't able to get to them within this hour, but we have provided Jenica's email and phone number so that you can reach her. Like she said, she's very accessible. So it should be fairly easy to get a hold of her. And then I guess just final thoughts, if you could make one recommendation to someone today, what would it be in terms of getting started in this process, either for themselves or their loved ones?
I say at the bare minimum, have a POA, an advance directive. If you already have those in place, pull them out, take a look at them, make sure they're up to date. If not, if you're comfortable doing so, contact an attorney, and then make sure your beneficiary designations are updated as well. Because even if you haven't completed any other documents, if you die, you can still avoid probate for certain assets by updating your beneficiary designations. And that's something that oftentimes we forget to do. Our life situation changes and we forget to make those important designation updates. So yeah, feel free to reach out to me. If I don't know the answer, I have a good connection of attorneys who, and other professionals who are going to know the answer. So I'm happy to chat with people on a follow-up basis.
Thank you. So thank you, Jenica, so much again for all of your wisdom and empowering us to take control of our legacy. Very important information. Again, her contact information is in the chat. And then we should probably brainstorm on future programs because there's so much information within this. So we'll be working on that, everyone. And then also, don't forget our upcoming programs in honor of this being Pride Month. You can join us on June 22nd at 10:30 to 11:30 a.m. This will be in person, and we will be focusing on successful aging strategies for LGBTQ plus older adults. So please join us for that. And again, have a wonderful day, and thank you for joining us. Again, thank you, Jenica.
Thank you.